Life, Loss and Legacy is a general information podcast only. This does not constitute professional advice as we simply don't know your individual circumstances. If you do have any questions, please be sure to contact the guests of the episode. It should also be noted that the opinions expressed by the guests and host of the podcast are theirs alone and do not represent the opinions or perspectives of their employer or any other associations. That's enough warnings. Let's get started. Hello and welcome back to Life, Loss and Legacy, a planning solo podcast dedicated to helping people navigating those first few years after bereavement. My name's Jordan Vaka. I'm an independent financial planner with Planning Solo, and I'm joined today by an estate planning expert, Kelly Gatehouse of Nurture Law. Thanks for joining us, Kelly.
Thanks for having me, Jordan.
Now, I will very quickly run through your bio because I've only just realised that you're also collaboratively trained, which is great. So Kelly is an experienced wills and estate lawyer. She's the founder and director of Nurture Law, a modern law firm operating in Queensland with a focus on wills and estates. Kelly's been recognised in Doyle's Guide as a leading Queensland estate litigation lawyer and is also listed in Best Lawyers in Australia in the area of trusts and estates. Excitingly, she's also trained as a collaboratively trained estate lawyer and is a member of the Australian Association of Collaborative Professionals and the Queensland Association of Collaborative Practitioners. We will be covering collaborative practice in another episode. It's a really, really interesting and exciting area of estates management. And Kelly's also a recognised trust and estate practitioner by the Society of Trust and Estate Practitioners and served as a committee member of STEP for many years. So Kelly, pretty significant sort of bio. So thank you for joining us. I'm looking forward to having a chat today. Can you tell us something about yourself briefly, because we have a lot to cover?
We do have a lot to cover, which is great. A little bit about myself. So I live in sunny Queensland. I have a 4-year-old and a 13-year-old stepdaughter. So we're pretty busy in our life. And yeah, I have my practice, Nurture Law, which I founded almost 3 years ago. So we are an all-female law firm, which is that's just not happened purposely, but it just has turned out that way. And yeah, we like helping clients with regard to estate planning, estate administration, and also estate disputes. And yeah, I'm collaboratively trained as well, which is really useful, particularly in that estate dispute space as well. So that's a little bit about me.
Starting a law firm in 2021, that's like the depths of COVID. Obviously, the Victorian experience is a little bit different than the Queensland experience, but I'm going to make a logical leap here and say that speaks to how comfortable you are with complexity and navigating difficult times.
Yeah, interesting times.
And
at that time, I had a 1-year-old too, so that added to it as well.
Yeah, hats off to you. Like that's a brave move. But I'm so glad you're joining me today because we're talking about the ins and outs of estate administration, which is, I think, something that's not really covered very well kind of in the general realm. And people are landed this role of being the executor, and then they have to do all these jobs that they may only have to do once or twice in their life, and it's a bit confusing and it's a bit overwhelming. So there's 3 broad areas I really want to cover today. The first one is just the mechanics of administering an estate, like what do you do with the different assets and the letters and things like that. Then talk about what support is available and specifically what can a good lawyer help you with as you navigate through that process. And also, if we have time to be a bit cheeky, what does bad advice look like from a lawyer? And then finally, the bit I'm actually quite looking forward to is what can go wrong, what mistakes can be made that people should be avoiding and what can they do about it. So I think we'll hop straight in and start talking about administering an actual estate. So somebody has passed away. There's a will in place, ideally. We'll talk a little bit about intestacy perhaps. But from there, they've passed away. What happens next?
Well, there's many roles and responsibilities of an executor or an administrator, who is someone who might act when there's not a will, so which is usually the next of kin of the deceased person. But sort of the first step would be organising things like a funeral and in dealing with things like burial or cremation of the deceased person. They're the immediate steps that would occur. Then the sort of, I guess, steps in the administration of the estate and the legal aspect of it then occurs. You really need to obtain the death certificate first. So that might take a couple of weeks after someone's passed away to receive the death certificate, but you can't do too much in an estate administration until you have that death certificate. And then from there, you're looking at deciding whether or not you might need to go and get what's called a grant of probate or a grant of letters of administration if someone's died without a will. And that's an application in each jurisdiction in Australia. The process is somewhat different, but similar in ways, and it's an application to the court essentially as a formal recognition of a person who is acting in that role as an executor or an administrator. So that would be, the steps initially. Sometimes various asset holders like banks, share registries, those sorts of things will not actually communicate with executors or administrators until they receive will have that grant of probate. So the quicker you can start that application process, the better. Sometimes you might not need a grant. In Queensland, we seem to be able to get away with it perhaps more so than other jurisdictions where you might not need a grant of probate. But, to deal with, say, a property, I know in New South Wales you certainly do. So there are intricacies in each jurisdiction, but it's important to consider at the outset, do you need a grant to be able to deal with certain assets? So, that's sort of the initial steps. And then, looking at trying to find out, what the assets are. It's always, and liabilities of the deceased person. Hopefully, the executor will know what they are, but they don't always know. Sometimes executors are going in quite blind as to what the assets and liabilities are of an estate. And there are various things we can do to try and, narrow that down and obtain that information so that, the executors making sure that they're collecting in the assets, paying the debts and doing their job appropriately. So there are ways we can do that.
And all those jobs fall on the shoulders of the executor or executors, doesn't it? I mean, really, they're the ones that will be administering all of this, them or the administrators that are appointed through the letters.
Yes, that's right. So it can be quite an onerous job at times. Mm.
And I think that point of when people come in blind, that must make it so much more difficult. So one thing ultimately, a lot of our work boils down to administration, like just recognizing what to do and when. So I'm curious about, okay, I'm an executor, probate's been issued, now I need to get started assembling everything. Is there kind of an order that you would follow when you're helping people with the administration piece of how to get the information they need in the different areas and to identify different assets and liabilities?
Yeah, so it's, looking at, okay, well, what records have they got so far? Do they have access to things in the deceased home, on the deceased computer, if they can access that, to try and gather as much as you possibly can, looking at maybe bank statements to ascertain, payments that are being made or money that's being received into an account. If that's, there's not much information at all, then we have to cast a very broad net and perhaps start writing to banks. Maybe if there are branches, not directly to the branch, but you look at the banks in their area, who they might have banked with, for example, write to the more common banks. There is also a national death notification service that you can enter in the deceased details and the death certificate information, and it will communicate out to a number of different banks or government agencies, those sorts of things, to notify them about the deceased person's death. So that's just, the banks though have to sign up to that service, so they're not all on there. Hopefully in time more banks will sign up to that, and it will make it much easier to gather information. There's also doing things like getting tax records, looking at what's occurred in prior tax years with assets, and also they would know about superannuation. The ATO would have a record of who the deceased had superannuation with. But sometimes if you want to sort of fast track that process, you might contact the deceased person's employer and see if they'll tell you, well, who did the deceased person have superannuation with? Contact financial advisors, contact accountants if they had engaged professionals prior to their passing. Previous lawyers who maybe had done the estate planning might have some records, hopefully, of their assets and liabilities. But I find that that's often when things are left in a mess. Perhaps those professionals haven't been engaged in the past, and yeah, it can be it can be
I can
difficult
see the
to obtain
correlation
information.
there.
Yeah, yep. So there's a little bit of work, but there are tips. Doing obviously title searches is fairly standard. We would look at properties that are held.
Is that
Hopefully,
something a layperson could do? Like if just somebody off the street can do a title search?
yeah, you can. Yeah, you can. I know in various jurisdictions you can do that. You can register online for an account and do a title search. Yeah.
I mean, there's a lot of work here, and we'll drill down even more into some of the detail. But I think we should flag this is very difficult to do when you're also grieving. I imagine there's a lot of work here.
Definitely.
Which is why we'll talk about what support is available, because it's a lot there. Okay, so I've spent 6 months of my life contacting banks who've been given the runaround and super funds and all the advice, and I've collected what I think is a comprehensive picture of what they've got. So I have a handful of bank accounts. We've got the home they lived in, maybe some shares, some property, some other bits and pieces. What do I do next? Can I assume the search is complete at that stage? And if not, how can I?
Well, I guess it's just exhausting all potential avenues and making sure that you've done that. There are time limits in which we need to be aware of in an estate administration. So in each jurisdiction, there are different time limits in which an estate shouldn't be distributed to beneficiaries. That doesn't mean you can't collect in the assets and sell assets if that's appropriate, but you need to hold those funds until that time limit has passed. Otherwise, an executor could be liable. On the other end of that, there is to consider administering the estate in a timely manner is also important, because if, say, for example, there might be a specific gift of money in a will of maybe a $100,000 gift to a specific person. If that's not paid within, in Queensland, for example, if it's not paid within a year of the deceased death, then there's interest that's payable on that from the 1 year anniversary. And my understanding
is paid by the estate.
The estate, yeah. So the other beneficiaries might not be very happy about that if the executor isn't administering the estate in a timely way. So we call it like an executor's year, essentially, that there's no strict time limit that an executor should have it done, the estate administration completed by, but generally speaking, it's a year that you would expect, because there are a lot of things that need to be done.
You mentioned, I think, was it calling in assets? Is that the terminology?
Well, so yes, there are things like calling in assets is one thing, but it's really writing to those entities to find out, well, what are the assets, what did they hold? Writing to the share registries it's quite administrative in nature, writing and just trying to ascertain things. And sometimes it happens where things will be missed, and years later, the executor will get a letter saying, "Oh, here's a check for XYZ." Unfortunately, because sometimes you just can't. If you don't know, obviously you check unclaimed monies. That is something to do as well. Check the unclaimed monies registry to see if there's any money there sitting there unclaimed. But it does happen.
I was talking to someone the other day, another estates lawyer, and they're working on an estate at the moment where the deceased's parents had some shares that they bought in America and like 30 years ago. And so they were having to write to a share registry in Delaware to try to get the information and they only pay out by check. So there's really, really involved schmozzle of an administration process. So just to say to people listening that if you're finding it frustrating, it is. There's not really too much you can do about it. It's just you have to go through the steps that are required. So I contact the share registry, contact the bank account, other banks. When I contact them, do they change the name of those holdings?
Yes, they will. So it'll be changed into the name of the estate. They'll have requirements where you'll have to provide, certified copies of ID and, the grant of administration, which will have the will, the grant of probate, which will have the will with it. All those sorts of things need to happen, and they'll change it over into the name of the estate. And then consideration needs to be given to things like, well, are beneficiaries going to retain certain assets? So shares, for example, might be something that they want to keep rather than them being sold and them receiving cash. So that's something to think about. An executor should be communicating with beneficiaries on because there could be pros and cons from a tax perspective as well. Retaining assets or selling them. So there's things like that need to be considered before sort of disposing of them.
And how does a beneficiary make that nomination? If they say, I'd prefer to receive the BHP shares directly, is there a formal process they need to go through?
Well, they need to be communicating with the executor about that. The executor should, write to them, particularly around, say, assets like shares, property, seeking their views at an early stage too, as to whether they want to retain certain things and how that might work. Advice would need to be obtained from accountants about things like capital gains tax and who's going to be responsible for that if there is capital gains tax payable when an asset's being transferred.
I'm really getting into the weeds here because I'm just interested in this particular point. But so say I nominate, for instance, those BHP shares, but then the executor sells them on me anyway. Is there any responsibility on the executor to me in that case?
Not necessarily. It's they, for example, like if there are multiple beneficiaries who want a particular asset, and they can't agree on that, it's likely the executor will sell them and divide them as per the will, because that kind of resolves the issue if an agreement can't be reached. But there's no requirement necessarily. They can dispose of assets, particularly, there might be debts that need to be paid, and you can't stop them from selling them if they need to sell them to pay those debts. But an executor should, be communicating with the beneficiary, and generally they will do that. But as I said, there might be instances where they just can't keep the asset.
Yeah, there just may not be enough there to cover the ongoing costs. But
Yeah.
Once they're in the name of the estate of, the executor can transact on all of the assets as per the deceased would have been able to. Is that right?
Yeah, so usually what will happen is they'll either utilise a solicitor's trust account or will open an estate bank account. So what that means is, for example, the deceased bank accounts will be transferred into the name of the estate, but then they need to be, paid into, say, a trust account or a deceased estate bank account for the executor to be able to transact on that. So sometimes solicitors will utilise their trust account for that purpose, but it's also important that if an estate's going to be held up for a time period for whatever reason that they consider investing that money, and a duty of an executor is, to maximise the estate, essentially. So they should invest it if they know there's going to be a delay in distributing those funds to beneficiaries.
So executors shouldn't be transacting of like Jill Smith's old bank account that's now in the name of the estate of. That money should be transferred to a deceased estate account, and then that's the transactional account.
That's right, yeah. So the deceased person's bank account essentially gets frozen when the bank knows that the person's passed away, and they shouldn't transact on that account after the person's died. That's not to say it doesn't happen, but that's not the appropriate way.
So all of the money then gets collated into the deceased account. The bank will then close all of the other bank accounts, I presume, once they hit the zero balance?
Yeah, and then if there's, say, like a credit card debt, they might take that out of the other funds that are there. That's
one thing I was going to touch on. Yeah, with the liabilities then, if they're with the same institution, do they have the right to use that cash to clear those debts?
Usually the contractually, like that's their right to do that. May not be right though, because if it's an insolvent estate, there might be an order of priority about how debts are to be paid. So it's looking at, well, what's the contractual right of the bank to do that? But it happens where there'll be a credit card debt. Hopefully, it's not much, and it's okay. I haven't seen it become a major issue, but yeah, they will usually just take it.
So it's something to be aware of, I think, for the executors that might
Yes.
get surprised by payment. It
Yes.
is often quite legitimate for the bank to do that. And we will
Yeah.
touch on insolvent estates a little bit later when we talk about the problems that can arise, because I think that's quite interesting for people, particularly, I mean, to generalise, in Melbourne and Sydney, like debts are so big against houses that they can chew up the estate pretty quickly. So I think insolvency is something that people should be a little bit more aware of.
Mm-hmm.
So then the bank accounts are closed, shares can be sold. Then the money's distributed to the beneficiaries as per kind of the timeframes that are given. Is the executor's job finished then?
Well, before they distribute the estate, they need to be doing things like making sure tax is dealt with. That's a really key and very important step that needs to be taken. Getting appropriate advice from an accountant about what other outstanding tax returns prior to the deceased passing, but also does a tax return need to be lodged on behalf of the estate, and making sure that any tax liability is paid. Otherwise, the executor could be personally liable for tax. Yeah.
So if you
So
pay out
that's
everything and then you get a tax bill, that could fall on the executor to pay that if they've paid it out too quickly.
That's right. So that's a really, really important job to consider, and getting advice from professionals.
You mentioned tax returns that are outstanding at the time of the deceased passing. So that's a responsibility of the executor as well, to make sure they're brought up to date?
Yes, that's right. And it has happened in deceased estates where they can be outstanding for sometimes many years, and it can be quite onerous, and it's really important to seek advice from an accountant, perhaps someone who specialises in deceased estates, because there are, some important requirements for executors to what lengths do you go to when you're doing returns for someone who has passed away and they're historical. How much information do you need to gather? What do you need to do? So it can be it's very important to get some professional advice around that.
Yeah, I think absolutely. I mean, that sounds so complex, and if they've been involved in maybe trusts or companies that also aren't, those affairs aren't up to date, that falls on the executor as well.
Not necessarily. So it depends on, the deceased person may have been a director of a company. That doesn't mean that the executor necessarily has to take on that role. For example, the company might be insolvent. They might actually get a liquidator appointed. That might be a more appropriate step to take. So it's just looking at the company as a whole, and whether or not the executor wants to take on that responsibility as a director of that company after the person's died. It's not a requirement that they necessarily do. I mean, most of the time, if there's assets in it, they'll take on that role, and if they need to sell the business within that company, or are they going to keep the company trading, for example, the business trading. So there are lots of things to consider when there is a company involved.
I think the people that are listening to this are likely, I envision that they're in that position where they've inherited some of this complexity and they're kind of trying to work out what to do next. And the recurring theme I keep coming up against in recording this is you really need to go and find good advice. You need to find good professionals in different areas. So I'm curious, you've mentioned accountants. What other professionals should people be talking to along the way of administering an estate?
Yeah, it's so interesting. I saw a post on a Facebook group the other day of someone. She was looking for her unicorn, and it was her wanted someone that could give advice on tax, legal, financial, all in one.
Oh wow!
And I think there is this, I guess misconception that is something that one person can do, but it's just not. Unfortunately, you generally will need advice from a lawyer and an accountant, and then sometimes financial advisors, depending on what's happening in the estate. But yeah, they're sort of key people that you may need to involve. They all can't do that. Sometimes there are tax lawyers that we might need to get involved on a technical aspect of an estate. Particularly like if there's a life interest or a particularly tricky capital gains tax issue or something like that, you might. But yeah, it's really important to think about who is on your team, who is helping you to administer the estate. There are certainly things that executors can do themselves, and it's often a good idea in terms of saving on costs, because engaging professionals can be expensive. But so there are things that executors can do themselves, like notifying, Services Australia about the deceased person's passing, like those sort of more simple tasks, most certainly, and then engaging a solicitor and other professionals to provide advice and handle the more complex aspects of it.
How do you manage that delineation of roles when you're working with somebody through an estate administration? Do you sort of say, here's a list of the things that you can do yourself that could save you some fees? Like, how explicit do you get around that?
Yeah, we certainly sort of scope out the work that we're doing from the outset with the client, and we'll be saying, okay, well, these are the tasks that we're going to attend to. These are the tasks that you're going to attend to. If you find you're having roadblocks in the future with the things that you're doing, please let us know and we can help with that. But we very clearly sort of set out who's doing what in the administration of the estate.
One question, the unicorn idea is kind of frightening that they're looking for that through Facebook, because I think it's quite a hard space to land. But what kind of estate, I'm trying to think of the best way to word this, because you could do it all yourself, in theory.
Yeah.
But I get the feeling that's only really for simple estates. You wouldn't want to be doing this on your own with any sort of complexity.
No, like a simple estate that you could perhaps do the administration on your own is, for example, the deceased person might have had a pension, an age pension that was their only income, and they had a bank account that had a small sum of money in it, and perhaps the bank doesn't need you to have a grant of probate to release that money. The banks change their thresholds, but just some banks maybe, for example, they'll need probate if there's over 50,000 in the bank. They'll need you to have probate before they'll release the money. But all the banks are different. But that might be a reason why you could perhaps administer it yourself. It really just depends, though. I mean, there could be issues with the will itself that you need to get advice on. So, yes, as a typical lawyer, I'll say it depends.
The catch-all answer that keeps us all out of court. and so I think the idea of doing it yourself, if it's simple, I think there's reasons to engage a specialist. It's just too complex, it's too challenging. I just don't understand the rules here. I'm a bit confused by what's going on. My family are making this really difficult on an interpersonal level, so I want a third-party kind of intermediary. There's all these reasons to engage a specialist. So I am keen, because I think a good lawyer should be the first port of call. I can say that. I think I'm not promoting anything there. I think a good lawyer to help you through the administration is really important. So can you walk me through what a good lawyer in this space kind of looks like? What should people be looking for?
Look, I mean, you definitely want someone who has experience in the space of wills and estates. You want someone who practices in the relevant jurisdiction that you are in. So that's important. The laws around deceased estates vary in each state and territory in Australia. There are similarities, but they do vary.
Sorry, Kelly, just to jump in there with the jurisdictional question. What if I die in Victoria and I own assets in Queensland and WA, which jurisdiction should be the primary one when somebody's looking for a lawyer?
Usually the domicile of the deceased person, so where the deceased person lived. Okay. That's where you would be administering the estate. Yeah, yep. There are there can be significant cross-jurisdictional issues, particularly if, say, someone If there's issues around, well, where was the deceased domicile? If they might have lived and worked week about in places, there can be issues around that sometimes. If maybe they've got assets overseas, there are lots of that's definitely a more complex estate administration, and getting advice, you might need to engage solicitors in Australia and in an overseas jurisdiction as well. So that's to consider as well. Yeah. So yes, thinking about, well, where the solicitor is that you need to engage is important. Having that experience as a wills and estates practitioner is important. Also, a solicitor, I think, who is upfront about their fees, and I very much am a believer in fixed fees where possible. So I think that is important. Unfortunately, when solicitors maybe are acting on hourly rates, they'll give an estimate, and at the end, sometimes it can blow out. Not through anyone's fault necessarily, it just can happen. So fixed fees, I think, is a good idea, and having that transparency is important. So I think they're sort of the key, and engaging someone that you feel comfortable with. You're in you're grieving the loss of a loved one, most likely. You're an executor, probably a family member, and that's a really tough time. So someone that you're comfortable with, and that you feel like you can be open and that's approachable for you.
And I think you can't tell this when you first meet somebody, but I think somebody that plays well with others, because if there's complexity, you're going to have other advisors that you'll need to involve. And I think that works a lot easier if everybody can pick up the phone and have a chat, and it's not really weird and sort of confrontational.
Definitely, particularly if there is, say, a dispute involved. It is helpful to have someone who, is collaborative in their approach with other practitioners, most definitely.
I think that's where that experience piece kicks in as well. Like if you're experienced in managing estates and managing disputes, then that should bring a lot more beneficial experience to the process there. You have multiple lawyers in your firm, don't you?
Yeah, well, I have myself and another lawyer, Christy. Yeah.
So part of me's thinking that that's a good sign as well. If there's more than one lawyer, not to sort of besmirch the name of single operators, but there is a key person risk there that if something happens to them or they get overwhelmed or anything, having an extra lawyer, I think, around helps with that.
Oh, definitely. And like Christy and I will often work on matters together. She'll do various aspects of it. I'll do other aspects, or I'll oversee certain things. So it definitely helps. I can't be available 100% of the time, and neither can she. So it's good to have, a number of lawyers potentially. And we've got a really good paralegal as well, who will often help with administrative parts of an estate administration. She's very seasoned paralegal. I've been doing this for years. She probably knows more about it than me.
And I think because estates can kind of just expand so quickly, the work that's involved.
Yeah.
I think a single operator, and look, I'm a single operator in my practice, but you can be overwhelmed, I think, if you have too much going on at once, and estates can kind of surprise you.
They can. It's
a very gentle kind of pathway into, if you would like to share some signs that maybe the legal advice you're getting isn't as good as it could be.
Oh gosh, this
we'll
is
make
dangerous.
It just advice. I'll do the same thing.
I guess, I think if a lawyer takes maybe a cookie cutter approach to an estate administration, that's not necessarily great. There are certainly services that offer, we'll just get a grant of probate for you, and you can do it online, and that's it. That's this legal service. I don't think that's necessarily appropriate for number of clients. You often need advice around things like, well, what are your duties? What are your responsibilities? You need someone that's in your corner protecting you as an executor in that role. It's an onerous role, and you need to make sure that you're doing it right so that you don't find yourself in breach of your duties. So I think it's, a lawyer perhaps providing that cookie cutter approach is not necessarily appropriate for estate administration.
Mm.
Yeah, and perhaps someone who doesn't have necessarily the experience in wills and estates, there are certainly generalist practitioners out there, and I think that we need general practitioners, particularly regionally and things like that. It's definitely good, and some of them probably have significant wills and estates experience, but some of them may not. So it's just knowing, well, what's their background in that area? Are they the right solicitor to help you? Talking to perhaps other professionals who might be able to recommend someone to you who is appropriate to help in that space. But yeah, I think it's just knowing a bit about the background of that lawyer and what they do.
And I think it's completely valid to ask people or advisors you're engaging is, how have you helped people like me in the past, and get an idea from that. Like, there's nothing wrong with asking that. And I cookie cutter advice, very much on the financial planning side as well, is not appropriate, particularly in this kind of space, I think. I would add to that, possibly, you want them to be responsive, but you don't want to have unrealistic expectations of their responsiveness. So if you're expecting your lawyer to get back to you within an hour of you calling them on a Tuesday, I would argue that's unrealistic. But I think it's reasonable to expect them to maybe get back to you by the end of the next day, or just to stay in touch, maintain communication. But there needs to be a reasonableness there. If you're not hearing from them with it for weeks, that's an issue. And I think
that's definitely a red flag. Yeah, yeah. Most definitely. You need to be able to communicate. There's nothing worse than when you're an executor and you've got all this worry already and you're grieving, and then you're having anxiety about your lawyer not getting back to you. Yeah, definitely. It's very important to have that communication. And another aspect of it, which we covered previously, is, making sure it's really clear what are they doing for you, and what are the time frames in which they're doing that.
Is it hard to change lawyers kind of mid-estate?
It can be, because there can often be then further costs involved in engaging a new lawyer to review things that the previous solicitor has done, and to get on top of that. And it can cause further delay. That you might also have like a deferred payment arrangement with your previous solicitor, and they're then demanding their payment because you're terminating their retainer. So solicitors in deceased estates will sometimes defer payment of their fees until the estate's assets have been brought in. So that can occur. And when your lawyer is engaged on that basis, they may not be too happy then when you're then terminating their retainer, and they'll say, well, you've got to pay me before I'll release your file. So it can be harder to change lawyers, but it shouldn't be a deterrent if you're feeling like you're not getting the right advice, because it's very important to make sure you're appropriately advised.
Because it's on your head essentially during that.
Yeah.
I think we managed to go through that without burning all of our professional bridges, which was nice.
I know. All my lawyer friends are going to hate me.
So what none of your lawyer friends are giving bad advice, so it's safe. That's
fine.
No,
it's that's true.
We're talking about it's
all great.
But we might pivot from there into the final section I wanted to cover off, which was what could go wrong. And I said at the top of this, I'm very excited about discussing this, and I realize that can sound a bit callous because these are really awful kind of things that happen. But for us, the technical stuff that's involved in some of these problems is quite interesting and fascinating. So we might hop into one of the problems you flagged in a conversation we had earlier. I'm the executor, I'm administering the estate. What can go wrong with the will itself?
So it's really important as a practitioner, when I have a will come on to my desk, to look at, well, is it an original? Does it look like it's been, there's staples missing? Has it been tampered with? Is it signed appropriately? So looking at, well, what does the will actually say? Like, who's being appointed? Are all the bits in the will that we need in there around, say, revoking previous wills? So we have a really good inspection of the document at the beginning. But often what can happen, issues around wills are, the original might have been lost, and say you only have a copy. So then we need to think about, well, how was it lost? Can you track back to, did a lawyer lose it? So unfortunately, safe custody does go missing.
We
And
had a conversation with Lucy Percy on the estate planning episode,
yeah,
and she mentioned this is like this latent issue amongst estate stuff is not the will. There's no central repository of wills.
no, which is a lot of people are shocked by that. There are private
I was.
organisations that, yeah, there are private organisations that are trying to have a registry, but I just think unless it's mandatory, then that it's just we're never going to have a central registry of wills in Australia. But yes, so wills go missing, and people have them in their home, they move, things happen, there's fires, floods, things occur, and wills go missing. So sometimes you might only have a copy of a will, and then you need to get advice around, well, can you get probate of a copy of the will? There are certain circumstances where that might happen. So, for example, if you can prove that, well, it was the lawyer who lost the will in their safe custody and it was last tracked to them, you probably have better chances of getting probate of a copy of the will. Whereas if it's, for example, in the, it was last in the hands of the deceased person, if that original can't be found, there is what we call a presumption that they revoked it. So we have to overcome that presumption and try and find evidence that there was an original at some point, the deceased didn't destroy it, didn't revoke it, whatever it might be. So it's just looking at gathering evidence and working out, well, what you might do if you've got a copy.
If you can't overcome that presumption, does it eventually result in them being declared intestate?
Yes, yeah, that's often what will happen.
Yeah, right, okay.
You also need to look at, like, are there previous wills, but that signed will might have revoked that previous will. So it's just looking at, well, what are the circumstances, what's previously occurred with wills. But yeah, and often we sometimes on a wild goose chase contacting law firms in the local area, putting notices in the paper for a missing will, or in our local, like our Law Society magazine, asking lawyers to search their registries, and we'll be contacting the public trustee, and so we're often on a wild goose chase sometimes trying to find wills. Wow. Which is other issues that might happen, you might have an informal will. Someone might have written a note and not actually had it signed or witnessed appropriately, and that's what we call an informal will. And you can apply to the court for the court essentially to say, well, that was the deceased person's last will. That's often a very expensive exercise, and it's not a straightforward process, and there are usually disputes between, say, the beneficiary named in that document and those who are entitled under intestacy, and it can often end up in litigation. But it's not as simple as let's just go to the court registry and get them to approve that informal document. It's a lot more complex, and you've got to very much look at the evidence surrounding that document as well.
I had somebody, it was a few years ago, I think an informal will, there was an SMS, had been accepted by the court. And so a friend of mine went away and she SMS'd me a will. And I'm like, well, this isn't a will. Don't do this to me.
Yeah. Text messages, notes on a phone. I think years ago there was a case, there was a note on like a beer carton. And just, things, people will prepare things, and, not having previously perhaps engaged a lawyer, or not being aware of those formal requirements, around a will, they'll prepare them and think that that's all okay. But it creates so many complexities. Yeah.
Get specialist advice. Get a professional expert solicitor to help you draft your will. Don't do it on the
definitely. Yes.
Slab of beer you just drank, because that might flow into questions around capacity, which you mentioned capacity as well.
Yeah, so that can be an issue when after someone's passed away, particularly if on their death certificate there is a mention of things like dementia, Alzheimer's, and the medical profession will often sometimes not say the period of time that the person had that condition when they fill out the cause of death sort of information to go to births, deaths and marriages. And then therefore there's this sort of, you've got a death certificate that says dementia, and when you're then submitting an application to the court for probate of a will, and the court kind of goes, or the registry goes, well, there's mention of dementia. Did they have capacity when that will was made? So we sometimes will need to go off and gather evidence, perhaps from the estate planning lawyer. They might have obtained a letter at the time they made the will to say a letter from the doctor to say the deceased person had capacity. Sometimes we're having to write to the GP or gather other evidence to show that they had capacity at that time the will was made. So it can create some problems there.
So it's not necessarily beneficiaries that bring it up. It can be the court while they're looking at the probate documentation.
Yes, it can be, but it is, beneficiaries, or disappointed beneficiaries, or disappointed people who are perhaps beneficiaries under a previous will who don't like the most recent will may take issue. Definitely that happens. We call that solemn form proceedings. So that is where we're challenging the validity of the will, and that might be because of issues around capacity, but also things like undue influence or suspicious circumstances around the creation of the will. So they are sorts of actions that occur, and they're usually quite costly and lengthy court proceedings that occur in that regard, but that definitely comes up.
I feel like elder abuse is a big topic of discussion on our side, coercion, things like that. It seems to be becoming a more prominent aspect of estate planning and awareness for everybody, because it's some awful stories. I don't know how I can segue from that to the next one, but another thing that you mentioned before we started recording was the difficulty that can come with identifying beneficiaries in an estate. So I'm curious to talk about that a little bit, because that was quite interesting.
Yeah, so for example, you might have a deceased person who has left their estate to their children in their will, and those children aren't specifically named, it's just to my children. So then you're looking at, trying to identify who the children are, and sometimes there can then be paternity disputes if there's a child who the deceased person perhaps wasn't on their birth certificate, or there's no presumption in the deceased person's lifetime that they're that person's parent, that the deceased was their father. So there can often be issues around paternity that we might have to resolve after someone has died, getting things like DNA testing done. It's always better to get DNA, not that I'm a DNA expert, but it is always better to get DNA testing, I believe, between a parent and a child. It's more accurate than, say, getting siblings to do DNA testing. So sometimes we're having to try and find DNA of the deceased person, whether it be if they've had an autopsy, we might get the coroner to approve the release of body tissue or whatever it might be, or write to different pathologists where the deceased might have given blood, and then we're looking at trying to test, doing DNA testing to prove paternity. So that can often be an issue. And also if that child, they might not be a beneficiary in the will, and they might want to challenge and make a claim on the estate, they will need to prove paternity to be able to do that if there are issues about their paternity.
Under the family provision side of things.
Yeah. So if they are looking to make a family provision application and they can't prove that they're the deceased child by, say, a birth certificate or some other evidence that the deceased accepted them as a child in their lifetime, for example, then they'll have to get that evidence and prove paternity. And if they can't do it by DNA, they can apply to the court for a declaration of parentage, which is a whole other process. But that is sort of the next step. But the best thing is get DNA. Like, that's pretty good evidence if you can. But they're interesting ones.
We had David Patkin recording an episode around the role of the executor. And he made a comment. He said, people have been dying for a very long time. So there's a case or a case law or a situation that covers just about every possible scenario.
Yeah.
And you're just saying they're a declaration of parentage. Like that is something I never would have possibly considered, but obviously it's been required, and so we have a process for it.
Yeah, that's in most jurisdictions. That's in our legislation. That process is in there, and then there are cases that will consider, well, what kind of evidence will they have to provide to prove parentage? It would be looking at witnesses, getting the mum to perhaps provide evidence around their parentage, all those sorts of
Wow.
things. So yeah, it can be quite extensive, and it can be a costly process. Usually, what happens is the parties will figure out a different way, for example, via DNA if they can, and then they'll sort of accept, well, okay, you've got DNA, you're a child. I don't think it would be very difficult to dispute a fairly accurate DNA test. Yeah.
Um, and kind of flowing on, I mean, a big part of my work or my professional work is life insurance and the benefits of life insurance and superannuation death claims. Now, just to eliminate any mystery, superannuation payments are not an estate asset, correct, unless they've been nominated to go through the estate. What
That's
about
right.
life insurance?
Life insurance, it will depend on the beneficiary as well, but the estate can be a beneficiary of life insurance if there's perhaps no nomination and that's what the policy says, or so it can form part of the estate. And interestingly, which a lot of people don't realise is that life insurance can't be used for the payment of debts. So if it comes into the estate, it can't be used, for example, to pay the deceased person's mortgage. A number of years ago, I had a case where what occurred was the deceased person left a will, and it gave a property to a friend, and that friend was the executor. So she got in the life insurance, and the will said, I leave the property to her debt free. But then the residuary beneficiaries were some nieces of the deceased, and they, of course, so the executor friend, she used the life insurance to pay out the mortgage, and which was not right because it should have gone to the residuary beneficiaries, the children, because it shouldn't be used to pay, life insurance shouldn't be used to pay debts. So
That's a legislative requirement.
it is, yeah, under the Life Insurance Act. Yeah,
So just to play through that, because I think it's well worth emphasising that I have a life insurance policy of $1 million. I have a mortgage of $1 million. I pass away. We've closed all the bank accounts. We have the deceased estate bank account. $1 million from the insurance gets paid into that bank account. Neither my executor or the bank can use that to clear the mortgage.
that's right. It shouldn't be used. If you're putting you'd want to quarantine it. I mean, I'd be advising banks can do all sorts of things, but you try and
So have it paid into an account that isn't
as an executor, you want to quarantine life insurance most definitely. It can be used to pay things like funeral, like expenses that have been incurred by the executor in administering the estate. So it can be used for those things, but not for the payment of the deceased debts.
And so that doesn't apply if it's been left to the beneficiary directly. So if
That's right.
In that scenario I just said $1 million went to my wife outside of the estate, she could then use that to clear the mortgage and keep the house.
Yeah. And even if she's a beneficiary under the will, like if she receives the entire estate and the life insurance form part of that for whatever reason, she could, when she receives that money, she could decide to use that to pay the mortgage if she wanted to. But yes, it's in the Life Insurance Act. So it's really important for executors who particularly don't have that personal interest in the estate as a beneficiary to make sure they seek appropriate advice about what they're doing when there's life insurance involved.
So, I mean, we'll come into the topic of insolvent estates now, but does that mean in theory there could be estates that have had a big cash insurance payout but are technically insolvent because that money can't be used to clear the debt?
That's right. Yep.
Oh, wow.
Can occur.
Okay. Let's talk a little bit about insolvent estates. So you mentioned earlier, well, first we'll start, what is an insolvent estate?
So when there's not, so just, it's essentially like a bankrupt person. There's not enough money in the estate to pay the debts of the deceased person. To put it simply, yeah.
And so what does the executor have to do in that case?
So there's an order of priority about payment of debts, which works very similarly to Bankruptcy Act, which would apply to a person in their lifetime, but it looks at things like secured assets, non-secured assets, but then it looks at, well, who pays that out of the estate. So in a will, for example, you might have beneficiaries who are entitled to a set sum of money, and then you'll have residuary beneficiaries. And usually the residuary beneficiaries, unfortunately, they're the first ones to have the debts are paid out of. Sometimes there might not be enough in that residuary estate to pay all the debts. So then we have to work out, who, through a process of marshalling, we work out who pays what out of those other beneficiaries who are receiving specific gifts. So it can be quite complex. So even if there are, it's an insolvent estate, you might think, oh gosh, I don't want to involve a lawyer because there's just not enough money to pay a lawyer. It's so important for an executor to get advice, and legal fees they have priority to creditors. So expenses incurred by an executor, like legal costs, have priority to other creditors of the deceased, so they can be paid first. But it's so important to get advice when there's an insolvent estate, because you want to make sure you're paying the appropriate creditors out of the appropriate funds.
And so, is there a situation where the beneficiaries wouldn't get anything and the creditors would get paid like 50 cents in the dollar of the debt, and then it's wound up?
Yeah, that certainly could happen. Yep. So that's the process of marshalling where that could happen. And, unfortunately, yeah. But yes, insolvent estates are a lot more complex. And it's, as I said, I think the best advice to an executor in that position would be also think about whether you want to take on the role to start with. Do you really want to take on the role of an insolvent estate?
We haven't painted the greatest picture of it, have
no, we really haven't. No one's holding a gun to your head, but whether or not you think about that, but if you do, then seek advice.
Yeah, absolutely. I think, it's a challenging one. That'd be very, very difficult to maintain that. One thing that popped into my mind earlier, is there like a point when you can say the estate is finished? Is it just when everything's been paid out? Is then you draw a line under it and that part of your life is finished?
Yeah, so essentially, you're once you've got in all the assets, paid the debts, dealt with tax, then communicated with the beneficiaries, make sure you're identifying them appropriately, doing things like bankruptcy searches on the beneficiaries. If they're bankrupt, there can be consequences if you pay out an estate to a bankrupt beneficiary rather than their trustee in bankruptcy. So doing bankruptcy searches is a good idea. Making sure, you're identifying them appropriately. They've provided you with all of their ID. And sometimes you might want them to sign like a deed of release and indemnity to protect the executor. You might, if there have been issues with the beneficiaries along the way, you might want them to sign that. Beneficiary is not necessarily, you can't force them to, but it is always a good idea to try and get that.
And then there's no certificate of finalisation issued, is there?
No.
It's
it's
finished.
In certain jurisdictions, you do have to provide like schedules of assets and liabilities and like a final schedule to the court. There are certain, from my understanding, as I'm a Queensland practitioner, and we don't have to do that here. But other jurisdictions, there is that extra process, from my understanding. But yes, essentially, once all that's done, and the appropriate times have lapsed for potential claimants to give notice of claims or make claims, that those times have passed, and you can then safely distribute the estates to the beneficiaries.
With the life insurance falling into the estate and not being used to pay debts, does that apply to superannuation death benefits as well?
Oh, I knew you were going to ask me this. Please don't ask me this question. It's actually not. It's not a very settled area of law. So I've looked into this deeply in the past in a matter, and it's not. I believe it's treated differently to the life insurance component of super. So you could have super coming in, but
Oh, okay.
yeah.
Okay, yep.
So the super balance component is different to the life insurance component.
So the super balance component can be used to pay debts. That's fairly settled?
Uh, I wouldn't say so,
No.
but I don't
Okay.
believe that I don't believe there's a particular case, and I could be proven wrong. But I don't believe there's a particular case on that point at this stage.
On how either component is treated, it's still a bit grey.
Yes, well, the life insurance component shouldn't be used to pay debts, but the super component is grey. Mm.
Interesting.
Mm.
I always have an opinion that you never want to be a test case, but somebody listening to this may end up being a test
Yeah,
case.
they may.
Avoid it if you can.
I have people ringing me now saying, "Oh, can you run this test case for me?"
You'll now be the specialist. You'll set the
Yeah,
precedent. So.
yeah.
Congratulations.
Yeah, thanks.
One final problem that I think can arise, and I just wanted to pick your brain on that as well. What happens if there's more than one executor, and how can that kind of go awry?
Yeah. Hopefully, when people are making wills, that they think carefully about who they're appointing, and uh, you know, have people in those roles that perhaps get along. That's always a good thing. But yes, executors have to act jointly in their roles, and it can happen where you may have one executor going off and doing things and not acting with the other executor jointly, and that can cause problems and can potentially sometimes, if they're warring and they can't work it out, it can result in them being removed as an executor and someone else being appointed. It might be a lawyer who be appointed as an independent executor to act in that role.
Okay.
So that can occur, and which is
who would bring that action? The beneficiaries or the other executor?
Depends. Yeah, sometimes it's the other executor, sometimes it's the beneficiaries who have an interest in it. If the executors are causing such delay because they can't agree, and the beneficiary might then apply to the court. And sadly, unfortunately, executors can have cost orders made against them if those sorts of things occur. Sometimes, yes, the judge might make them pay the cost of that court proceeding if they've been behaving badly. So that can occur. And yes, and then perhaps a lawyer might be appointed in that role, and then that's an extra expense. So it's not an inexpensive exercise, and it's often when there's a dispute like that, we try and avoid that and we try and work it out between the executors, but sometimes it's just not possible.
This is genuinely the last question because it just popped into my mind. What happens if an executor dies during the administration?
Yes, so if it's a sole executor, then we need to look at if they've got a grant of probate. Sometimes what we call a chain of representation occurs, and you might then have the executor of that person's estate that can administer the first deceased person's estate, or if there's a co-executor. So let's say there's two or three executors, the other executors will continue to act. So it just depends on what's in the will and things like, well, who's obtained probate previously, and yes, but someone needs to essentially step in and finalise the estate administration.
Yeah, so it's just, where does the wheel sort of spin to and land on, and then you
you just need to look at the circumstance.
Kelly, we will draw it there. We've covered so much ground, and we went down a few rabbit holes that I couldn't get a bit obsessed with. So thank you. I dragged us down there. So thank you so much. Thank you for all the information you've added and provided. If anybody wanted to get in touch with you, where's the best place to reach you?
So they can hop on my website, which is nurturelaw.com.au. So that's NURTURE law.com.au. I have people spell that differently for some reason, but
I thought that might be the case.
Yeah. And I'm on all your usual socials and Instagram and Facebook. You can look up Nurture Law on there as well.
Fantastic. And you're based in Brisbane?
Yes, Brisbane's on the south side, but we service clients all throughout Queensland, and often we'll have deceased estates in Queensland where the executor might be interstate as well. So yeah, we help them out too.
And if anybody wants to run a test case on defining the death benefit treatment, There we go, superannuation.
Thanks.
That was nurturelaw.com.au.
Thanks, Jordan.
Kelly, thank you so much. Thank you for listening again. Please tune into other episodes. If you have any questions, you can reach me at jordan@planningsolo.com.au. That is JORDAN, because it's similar to nurture. I've had that misspelt as well. So, if you have any questions, just reach out. And until next time, we will speak to you soon. Thanks a lot.